In this video, we will briefly revisit Article 2's gap filler provisions in order to examine how the UCC limits the freedom of contract parties to opt out of those gap filler provisions. Recall, by gap fillers, we mean the various provisions of the UCC that supplement the parties' agreement with relevant terms in the absence of the parties' express agreement on those terms. Gap fillers thus fill in the gaps in the parties' contract, where the parties' agreement does not address a specific issue but that issue is relevant to the party's legal rights or obligations under the contract. The gap filler provisions of the UCC fill in the gaps in the party's contract by supplying a relevant term to address the issue. Thus, when we covered gap fillers, we said that you can think of Article 2's gap fillers as merely default rules that bind the contract parties in the absence of the party's agreement otherwise. Where the parties' agreement has left one or more issues undefined or unaddressed, for example, when, where, or how the goods are to be delivered, the UCC's various gap filler provisions can fill in the gaps left open by the parties' express agreement, thus providing a reasonable basis for determining the rights and remedies of the parties in the event of a breach. Now we will refine our understanding of Article 2's gap fillers by accounting for the limits the UCC places on opting out of those default rules. And that discussion starts with Section 302 of Article 1. Remember, Article 1's provisions apply to all of the other articles of the UCC, including Article 2. Section 302 of Article 1 includes three subsections. First, subsection A states the UCC's general policy in favor of freedom of contract. Parties can agree to vary or modify the various provisions of the UCC that would otherwise apply to their contract. So, for example, the contract parties may agree on delivery or inspection terms that are different than the default provisions of the UCC. Or the contract parties may agree on who bears the risk of loss in a manner that is different than the default provisions of the UCC. Indeed, we saw in last week's module that many of the gap filler provisions in Article 2 expressly say that unless agreed otherwise, this rule applies to the parties' contract, making it clear that the gap filler provisions are merely default rules, that the parties may exercise the freedom of contract to agree to a different rule. But subsection C of 302 makes an important additional point. Specifically, it confirms that even when a provision of the UCC does not explicitly say unless otherwise agreed, that does not mean that that provision cannot be varied by the parties' agreement. Stated differently, even when a provision of Article 2 does not say unless otherwise agreed, that provision is still only a default rule, subject to the freedom of contract and the ability of the contract parties to agree to a different rule. So Section 302 of Article 1 seems to grant a broad freedom of contract, but subsection A includes two limitations. Except as otherwise provided in subsection B or elsewhere in the UCC. Let's start with the second of these two limitations, that certain provisions elsewhere in the UCC cannot be varied. Stated differently, certain provisions of the UCC are mandatory provisions. Subsection A of 302 does not identify which provisions are mandatory, but the official comment 1 to 302 adds that the specific provisions of the UCC that cannot be modified by the parties' agreement vary in explicitness, which is not particularly helpful guidance, because it basically says that a UCC provision may be mandatory, not subject to change by the parties' agreement, even though it may not expressly identify itself as mandatory. Think for a moment. What might be some examples of provisions in Article 2 that are mandatory, that cannot be modified or varied by the parties' agreement? One obvious example would be the statute of frauds. Indeed, that's noted in Comment 1 to Section 302. This makes sense. It would completely undermine the purpose of the statute of frauds if parties can make an enforceable oral agreement that includes a term that provided that the agreement would still be enforceable despite the absence of an adequate writing. If that were the case, one party could fraudulently allege that parties made that oral agreement and seek judicial enforcement of a contract that was in fact the product of a fraud or perjury. Another example might be Section 102 of Article 2, which defines the scope of Article 2. It would completely undermine the existence of the statute and the rules and policies created by Article 2 if the contract parties could simply agree that their agreement, even though it involves a sale of goods, is not governed by Article 2. Note here, even though the parties cannot completely contract out of the application of Article 2, the role of Article 2 can still be minimized by the parties' agreement. The contract parties are still free to agree to specific rules to govern the parties' rights and obligations, which thereby opt out of Article 2's other default rules. Likewise, the various formation provisions that we covered in a previous module. These rules deal with when and how agreements may be made and contracts may be formed under Article 2. It would not make sense if these kinds of formation provisions could be contracted out of. After all, until we know there is an agreement, we can't really think about what the terms of that agreement say or do. Similarly, the doctrine of unconscionability, like the statute of frauds, would be completely undermined if parties could include a term in their contract that provided that the contract is enforceable even if it is unconscionable. That would essentially gut the doctrine of unconscionability. Likewise, we might add that the parties to a contract cannot contract out of the other common law defenses to the enforceability of a contract. That is, defenses that are not codified in the UCC. For example, the defenses of fraud, duress, or mistake. Similarly, the parole evidence rule, a topic that we have not yet covered in this course, indeed a topic that we will cover in next week's module, is in part a rule about enforceability. It's a rule about when oral terms not incorporated into the parties' written agreement are or are not enforceable. A final topic that we have not yet covered in this course, but that we can briefly note now, is the remedy of specific performance. In particular, when the non-breaching party to a contract may be entitled to specific performance as a result of breach. As you may recall from your study of the common law of contracts, and as we will examine later in this course, specific performance is an exceptional equitable remedy, granted only upon the equitable discretion of the court. The party's contract cannot require a court to order specific performance, even if the party's contract says that specific performance is the remedy for a breach. This list suggests that at least to certain foundational issues, there is no freedom of contract. These provisions are mandatory because they are necessary for the rest of Article 2 to work as intended. So as a practical matter, there would be few instances, if any, where parties in the real world would have the need or want to opt out of these foundational provisions of Article 2. Beyond this list, however, it is unclear what other provisions of Article 2 are mandatory, because, remember, as Comment 1 to Section 302 points out, a provision in the UCC may be mandatory even though it does not expressly identify itself as mandatory. This brings us to the second limitation on the freedom of contract, except as provided in subsection B. Subsection B reads that the obligations of good faith, diligence, reasonableness, and care prescribed by the UCC may not be disclaimed by agreement. The parties by agreement may, however, determine the standards by which the performance of those obligations is to be measured if those standards are not manifestly unreasonable. So any provision of the UCC that includes an obligation of good faith, diligence, reasonableness, or care cannot be modified unless that modification is not manifestly unreasonable. The relevance of this Article 1 provision to Article 2 is in its application of good faith and reasonableness. Those two standards we have seen sprinkled throughout Article 2 so far. Consider several of the provisions from last week's module. As these examples show, we have seen several provisions of Article 2 that impose a duty of good faith or reasonableness or both, and many of these provisions do not expressly say unless otherwise agreed, like many of the UCC's other gap filler provisions do. Subsection B of 302 thus suggests that where such provisions do not expressly say unless otherwise agreed, those provisions are not quite just default rules, not mere gap fillers. It's true that the parties may agree to contract out of Article 2's default rules that require good faith or reasonableness, to agree to standards of performance that deviate from the requirements of good faith or reasonableness, but their agreement is enforceable only to the extent that the parties' agreed upon standard of performance is not manifestly unreasonable. So consider an example as it relates to the price gap filler that we looked at under subsection 2 of 305. Imagine you see this term in a contract between a bakery, the seller, who sells pastries and other baked goods wholesale to coffee shops around town. Press pause now to read this example contract term. As a pragmatic matter, you could well imagine why two parties in the real world would agree to something like this, especially if the pastries vary from week to week, so the cost of the necessary ingredients would vary. Is this manifestly unreasonable? Well, who's to say? Stated differently, how could a contract term be manifestly unreasonable if the parties actually agreed to it? It's not possible unless we think that one or both of the parties were unreasonable. After all, why would a reasonable person agree to something unreasonable, let alone manifestly unreasonable? Comment 1 to 302 sheds some light on that question. That comment says that nothing is stronger evidence that a term is reasonable than the fact that the parties fairly agreed to it. And this comment hints at the real intent behind 302 subsection B, which is that this section is really intended to deal with contracts of adhesion. where one party, say an unsophisticated consumer, agrees to terms drafted by another party, say a large fruit-branded phone manufacturer. In that situation, the party who is presented with the contract may not read or really understand what she is agreeing to, which in turn gives the drafting party an opportunity to overreach in drafting those terms, to draft terms that are wildly favorable to itself and to the disadvantage of the less sophisticated party. Thus, like the doctrine of unconscionability, the manifestly unreasonable limitation gives the courts another tool to police contracts, and it does so again by limiting the freedom of contract, but only at the fringes where necessary to ensure equity, to avoid injustice. So keep in mind, in the real world, Section 302, subsection B does not have much significance. The kinds of issues that subsection B of 302 addresses tend to instead be analyzed under the broader, more flexible doctrine of unconscionability. So to summarize, in this video, we revisited the UCC's gap filler provisions and noted that under Section 302 of Article 1, the UCC's gap fillers are not strictly gap fillers. Some foundational terms are in fact mandatory because they are essential for the rest of Article 2 to work as intended. And even as to the true gap fillers, those are not strictly default rules. Contract parties retain the freedom of contract to agree to different rules in the terms of their agreement, but the terms that the parties agree to must not be manifestly unreasonable, something that is unlikely to happen in the absence of unconscionability. In the next video, we will look at how the UCC Article 2 limits the freedom of contract when one party, the seller, attempts to disclaim any warranty made as to the goods that she sells.